Hello, my name is Samiksha Jadhav and I work as a senior associate at Riskpro India. Today, we would discuss about the penalties for the violation under the Digital Personal Data Protection Act of 2023. The Act places liability on the data fiduciary, significant data fiduciary, the data processor, and the data principal. If the board conducts an inquiry and concludes that there has been a breach of the provisions of the Act or its rules, a penalty suitable to the breach shall be imposed upon the party. Section 33 of the Act specifies certain conditions for imposing penalties. It states that a party accused shall be given an opportunity to be heard before imposing penalties. These penalties shall be imposed according to the schedule mentioned under the Act. However, while determining a penalty, the board shall take into account factors such as the nature, gravity, and duration of the breach. Second, the type and nature of the personal data affected by the breach. Third, whether the breach is of repetitive nature or not. Fourth, whether the person due to the breach has realized a gain or avoided any loss. Fifth, whether the person took an action to mitigate the data breach. In this case, one should also pay attention to the timeliness and effectiveness of such action. Sixth, whether the penalty that will be imposed on the person is proportionate and effective. Seventh, the likely impact of imposing the monetary penalty on that person. Now, the schedule of the Act provides for penalties for certain categories of data breaches. These are 1. If a data fiduciary breaches its obligation to configure reasonable security safeguards to prevent any such personal data breach, the penalty may extend up to 250 crore rupees. Second, if the data fiduciary has failed to give the board or the affected data principal a notice of that data breach, a penalty may extend up to 200 crore rupees for this breach. Third, if a data fiduciary fails to comply with the additional obligations with respect to children, a penalty up to 200 crore rupees may be levied. Fourth, in a case where the data fiduciary qualifies as a significant data fiduciary under the Act and he fails to comply with his additional obligations mentioned under Section 10 of the Act, a penalty up to 150 crore rupees may be imposed. Fifth, when a data principal does not comply with his duties under Section 15 of the Act. Now, for example, a data principal files for a false complaint with the board, or he impersonates as another person while providing information to the data fiduciary. In these cases, a penalty up to 10,000 rupees may be levied on the data principal. Sixth, if a voluntary undertaking was provided to the board and the board has accepted this undertaking, breach of the terms of such undertaking may attract proportionate penalties for that breach. Seventh, for breach of any other provisions under the Act or its rules, a penalty up to 50 crore rupees may be imposed. The business entities need to ensure timely compliance with the DPDP Act to avoid hefty penalties under the Act. Thank you.